did you have the feeling at that time that you were doing something that was quite historic? That that agreement would have far-reaching consequences for the whole way the multilateral trading system was going to be structured. That the creation of for example, a reinforced dispute settlement mechanism and the appellate body, that would have the power and the consequence that we're seeing today. Was that conscious there?
I had absolutely no doubt that this was the greatest institution building moment since the foundation of the IMF and the World Bank in the immediate aftermath of the Second World War. There was no doubt either in my mind that it was to provide the foundations for a globalized system of governance that went beyond trade itself, but could provide an example in other areas. We had just seen a number of momentous historic events, the collapse of the Iron Curtain, and, in the European context, the completion of the internal market, which was epoch-making at the time. And we had, in the letter, I remember, of application of the Chinese to join, a statement by China that they recognized that the essence of the market economy was competition, and that it was impossible to create efficiency and growth in the absence of a market economy system. That was the thrust of what they were saying. So here we had, for the first time in history perhaps, the possibility of creating a single global economic system based on rules. And the rule-based system was the key. For me, the area of particular interest, even before I became Director General, having been a former Attorney General of my own country, was the constitutional area. And in particular, the creation of the dispute settlement mechanism. I think that the great breakthrough in the WTO negotiations and conclusion of the Uruguay Round was the creation of the dispute settlement mechanism. I remember going to the United States at a time when the United States was still in the throes of ratification, and there was a concern that with NAFTA and with this, that perhaps we could have difficulties. And Newt Gingrich was leading for the Republicans at the time, and I remember him asking me about the constitutional implications, because the United States, of course, going back to the ITO in the late 40s and early 50s, it was sovereignty was the issue, and he was concerned about sovereignty. And I said, well, remember this, it's very different between, there's a big difference between the WTO and what it does, and what, for an example, the European Union does. Because in the European Union, you can enforce agreements through national courts. You can enforce community law through national courts. You cannot, of course, do that with the WTO. But notwithstanding that, whilst there isn't a direct encroachment in that way on national sovereignty, the fact remains that you cannot block an adjudication, and the effects of the adjudication can be serious and important in an intergovernmental sense. So it's the beginning of a move towards creating a single global rule-based system. It isn't a direct confrontation with national sovereignty, but it is the beginning of a real rule-based system that can work. So that, to my mind, was the key to the success of what was achieved and what was momentous about the creation of the WTO, which, as I say, was the greatest movement forward in multilateralism since the institution building in the immediate aftermath of the Second World War. The market system is, of course, a market system, but what we were concerned with was a rule-based system that provided support, particularly for the weak. The powerful have always been able to negotiate trade agreements. They've done it usually out of the barrel of a gun. But that day is gone. Now we have a situation where, particularly through the dispute settlement mechanism, but also through the whole negotiating process, the weak have rights. And I'm glad to see that after what I consider to be the ludicrous argumentation of many of these NGOs in Seattle, Cancun, and so on, that most of them have now joined those who would seek to defend the process that they should be defending, and the process that is vital, in my opinion, for a prosperous, growing world without conflict over trade. I don't think that the GATT Secretariat and the WTO are qualitatively different organizations. One is clearly grown out of the other. However, the whole dispute settlement structure is, of course, new. The focus on the WTO as an international organization has been enhanced, and the potential for the WTO into the future is greater than it could ever have been as a secretariat. It has an institutional existence, and that independent institutional existence, I think, has been reinforced by its creation and the way that it has developed.
Those things we knew from the very beginning were going to be groundbreaking. What we didn't know until we got further into the negotiations was how the dispute settlement system was going to evolve. For example, the original GATT dispute settlement system was much less effective, less binding, less comprehensive. And a lot of the negotiations in the Uruguay Round were about the trade-off between having the Americans rely less on unilateral measures in exchange for having a more effective binding multilateral system. Frankly, at the time, the Americans were very skeptical because my lords and masters back in Washington were not really too enthusiastic about the idea of the world's biggest economy giving up its kind of unilateral habits in exchange for some incomplete, vague, weak set of multilateral rules. So my role was to constantly say, if the U.S. is going to join on to this thing, the rules have to mean something. They have to be effective. They have to be binding. We have to be able to sell them to the Congress. Paul's role was to constantly talk about the dangers of unilateralism and of the U.S. going it alone in these kinds of things. You know, I think the U.S., which began as quite skeptical of the multilateral system, I think in the end became one of its, shall we say, strongest proponents of increasing and strengthening multilateralism.
And this is thanks to you.
No, I don't think at all. No,
you're the one who convinced people at home.
I think there was a big debate in the U.S. over acceptance of this. Remember, this tension has always existed in the U.S. between support for multilateral rules and desire to sort of keep its unilateral options open, and the GATT system never would have existed if it hadn't been for U.S. leadership in the post-war period. But then, of course, during the period of the 50s and the 60s, there were a lot, particularly in the Congress, who became quite skeptical of the GATT. And we had to demonstrate in the Uruguay Round how we were really strengthening it and making it effective.
I was called upon to preside the negotiations on institutional matters and dispute settlement in the final stages of the round, so I was completely directly involved in the final deals that created the WTO and that set up the new dispute settlement system. And those were very difficult negotiations indeed. And I like to think, I may be wrong, of course, that the way in which we managed to come to agreements on the institutional issue, creation of a World Trade Organization, and on dispute settlement, led the way to final agreement in the Uruguay Round. Because there was a moment when everybody felt the round had to conclude, but it wasn't concluding. There were too many loose ends all over, on anti-dumping, on subsidies, whatever matter you looked at, there was disagreement still. But if there was an agreement on the creation of a world organization that would give a juridical content to the whole system, which the GATT did not have, many countries felt reassured that there was stability in the system. And if there was agreement on dispute settlement, everybody also felt that if they had a grievance, they were going to be able to get results if they presented their grievance. So these were two big elements contributing to the peace of mind of negotiators and governments. And as I say, I may be wrong, but if you look back at the time, you will see that once these two basic things were settled, the rest began to fall into place. Now, on dispute settlement, there were, I think, two issues I might mention. One was the abolition of unilateral measures. In the past, in GATT, on certain occasions, and they, of course, they were always on important occasions, by its own volition, a country could frustrate the recommendations of a dispute settlement panel. And this had been a great weakness in the dispute settlement system of GATT. It had been improved over time, but this was a great flaw, in my view, a very great flaw, that did not give reassurance to the members of the system. This was done away with in the Uruguay Round. In the dispute settlement understanding, there is an express provision to the effect that these measures are banned. That was, to me, a very big thing, and it gave reassurance to everybody. The other thing, of course, is the creation of the appellate body.
On the dispute settlement, did you realize at that time the powerful system that you are created?
Yes, I think so. I think so, especially because there was such a commitment by countries who were not prepared before that to abdicate their sovereign position on those cases, especially the United States. In the United States, you have to remember that ever since the WTO went into force, the United States has never had recourse to unilateral measures. And despite having lost loads of cases in the dispute settlement mechanism, and the same with Europe, and the same with Brazil. So I think that that was, I think, very important, and I think we all realized, and that's why Ambassador Lacarte was always at will to fine-tune the project as much as he thought it necessary, you know, and very little was really discussed after that, you know. There was little changes from what he had been able to deliver from his group.
The U.S. actually had been more in favor of a more binding dispute settlement mechanism, where we were more legalistic in this sense. It was the European communities that for a long time had problems with the idea that there would be a more binding thing. So that was more consistent with a long sought out, because we use the dispute settlement mechanism and we wanted to make sure that countries were bound by it. Sure, it's used against us, as it should be, but No, I don't. That wasn't a hard sell, I don't think, with our Congress. I mean, I wasn't in on that bit of it, basically, back in Washington. You know, I went up to a few times with Carla Hills to testify and such, but she did the testifying. But I don't recall that being a major issue.
En faisant le plaidoyer pour atténuer ces dérives que j'ai toujours appelées néocoloniales, qui est le traitement spécial et différencié, la contrepartie pour aller dans ce sens, c'est d'avoir un système de règlement des différends qui fonctionne et qui soit équitable et qui soit plus proche de la common law que du droit positif romain. C'était fondamental. Les gens, quand on voit comment... Moi, je me rappelle encore, je peux vous citer des articles entiers, comment on les a construits. Et on avait toujours ce débat entre l'école romaine, qui était incarnée souvent par la France d'ailleurs. La France qui gênait beaucoup Paul, parce qu'il était très mal à l'aise. Il a eu beaucoup de problèmes avec la France, énormément. Et l'école, je dirais, un peu anglo-saxonne, même si elle n'est pas limitée aux anglo-saxons, et qui croient ont les vertus de règles extrêmement flexibles, dans la mesure où il y avait un sous-entendu entre nous, les gens de la Green Room, qu'on allait sortir avec un organisme de règlement des différends. Et là, je dois rendre hommage à une grande personne. C'était l'ambassadeur américain, le représentant permanent américain, Rufus. Et un homme qui incarnait la mémoire, qui était Andy Stoller. Je pense que souvent on oublie ces personnes, qui a été, je pense, extraordinaire dans sa capacité pédagogique d'expliquer aux Américains, c'est-à-dire au Congrès pour être précis, les enjeux de la négociation. Il ne faut pas oublier que la Constitution américaine ne permettait pas de fantaisie, disons, de marge de manœuvre à l'USTR. Mais il faut supposer, pour les historiens, un jour, du commerce multilatéral, comment les États-Unis d'Amérique, qui avaient toutes les peines du monde à accorder un fast-track aux négociateurs en chef, comment ils ont accepté un mécanisme de règlement des différends qui pouvait remettre en cause toute une vision extrêmement autarcique, sur le plan du droit, j'entends, et qui explique comment on a fait la Havane, etc. Et comment cela, je dis bien comment cela est passé inaperçu. C'est extraordinaire comment, à Marrakech, je me rappelle très bien, je discutais avec mes amis, et qu'est-ce qui vous a le plus frappé dans cette négociation? Personne ne m'a cité l'organisme de règlement des différends, sauf évidemment les grands négociateurs. Mais dans la grande masse des pays émergents, c'est quelque chose qui est passé. Et d'ailleurs, l'usage fait de ce mécanisme n'est pas tellement développé au sein des pays du Sud. Dommage. Aurait-on facilité, je dirais, l'accès des petits pays à cet instrument extraordinaire, on aurait changé les visages de la négociation. C'est ma conviction profonde. Et parce que chez tous ceux qui étaient autour de la table, et je me rappelle encore, et les propos d'Arthur, de Lacarte, qui était le Manitou de cette négociation, qui a fait un travail absolument exceptionnel. Si on avait compris que l'organisme de règlement des différends est un instrument de négociation permanente, parce qu'il permettait ce qu'un vrai tribunal à l'anglaise permet, c'est d'adapter la loi tout le temps au fait, à des situations particulières, donc lire la loi, fabriquer la jurisprudence. Et la vraie négociation, l'OMC serait une grande dame comme élément de la gouvernance mondiale si elle développait sa jurisprudence. Et en réduisant la négociation multilatérale, qui devient impossible à 153 ou 154 membres.
In the case of dispute settlement, I must tell you that I was pleasantly surprised because the new rules that were agreed in Montreal and became operational immediately afterwards, a few months later, they began to change the organization. You could no longer block indefinitely a panel, as I had experienced myself with the Americans in the case of the sanctions they applied against Brazil because of the lack of intellectual property protection to drugs in my country. The Americans would block our demand for a panel because they knew they would lose the panel. So that was a decisive change.
Did Canada, did the other negotiators at the time realized how fantastic what you created, the World Trade Organization, was going to be, the new dispute settlement system, especially you who became again active player under the WTO and now in the private sector? Are things different from what you expected, and at the time, did you foresee all this?
Well, we certainly didn't foresee everything. And I think, you know, we knew that we were involved in a negotiation that was of considerable magnitude. We were dealing with issues outside the framework of the GATT, services, intellectual property. We were trying to look at major improvements to the dispute settlement system, and this was an issue to which Canada had traditionally attached a lot of importance, because we were often dealing with larger neighbors and saw this as a way of mitigating disparities in power between countries. Does that sound like a north-south approach? So, it was the Canadian negotiating team that came up with this idea that perhaps the way to get around the fact that an increasing number of panels were not being adopted by the GATT Council because you couldn't get consensus to adopt them, that perhaps the way to get around this was to move to a system where adoption would become more or less automatic, but you would have the right of an appeal of some sort, which of course became, as you well know, a core element in the dispute settlement system. So I think there was a sense that we were doing something that was important, something that was valuable, that we were being creative,